Hello everyone, I'm Judiciary and I'm back with a new topic: independent judiciary, judicial review, and judicial activism. An independent and impartial judiciary is said to be the first condition of liberty. It is the custodian of the rights of the citizen. In a federal constitution, it also determines the limits of the powers of the center and the states. It is also the custodian of the Constitution insofar as it declares any law or executive or administrative action invalid and inoperative if it is contrary to any provision of the Constitution. It also declares any amendment of the Constitution invalid if it violates the basic structure or basic feature of the Constitution. The following provisions of the Constitution are intended to secure independence and impartiality of the Supreme Court and the High Courts. The President appoints the judges after consultation with judicial authorities. In case of appointment of Chief Justice of India, the President must consult such judges of Supreme Court and High Courts as he may deem necessary. For the selection of other judges of the Supreme Court, he must consult the CJI. The appointment of judges of the High Court will be made by the President after consultation with the CJI and the Governor of the state. In case of appointment of a judge other than Chief Justice, the Chief Justice of High Court concerned must be consulted. Thus, in the appointment of judges, the Constitution does not give absolute discretion to the executive. This position has been further strengthened by judicial interpretation which assigns primacy to the Chief Justice of India in matter of appointment of the judges of the Supreme Court and the High Courts, and the transfer of the latter from one High Court to another. CJI in this regard means a collegium of judges comprising Chief Justice of India and four senior-most judges of the Supreme Court for the purpose of appointment of Supreme Court judges and transfer of High Court judges, and consisting of Chief Justice of India and two senior-most judges for the purpose of appointment of judges of High Courts. The CJI shall always be appointed on the basis of seniority unless found unfit. Security of tenure is guaranteed to every judge. A judge of Supreme Court or of High Court can be removed on the ground of proved misbehavior or incapacity. The President can remove a judge only when an address has been presented to him against the judge by each House of Parliament. Salaries of the Supreme Court judges or salaries of the judges have been fixed by the Constitution and cannot be varied to their disadvantage by the legislature except during the period of financial emergency. Once appointed, their privilege, rights, and allowances cannot be altered to their disadvantage. The Supreme Court and the High Courts have been given authority to recruit their staff and frame rules regarding conditions of service. Expenditure in respect of the salaries and allowances of judges is not put to the vote of the legislatures. The administrative expenses of the Supreme Court, including salaries, allowances, and pensions payable to the officers, are charged on the Consolidated Fund of India. Similarly, administrative expenses of the High Court are charged on the Consolidated Fund of the state. The Constitution debars the Supreme Court judges from pleading or appearing before any court or judicial authority in India even after retirement. Also after retirement, a judge of a High Court can practice only in Supreme Court or in a High Court in which he has not been a judge. No discussion shall take place in the legislature of the state or in Parliament with respect to the conduct of any judge of Supreme Court or of a High Court in the discharge of his duties. Thus, our Constitution has done everything possible to make the Supreme Court or the High Courts independent of the influence of the executive and the legislature. Even the subordinate judiciary is independent of any extraneous influences, is only subject to the supervision of the High Court within whose jurisdiction it is. The Constitution also directs and facilitates separation of the executive from the judiciary and places the magistrate, which deals with criminal cases, on the same footing as civil courts. Judicial review. Judicial review in India is based on the assumption that the constitution is the supreme law of the land, and all governmental organs which owe their origin to the constitution and derive their powers from its provisions must function within the framework of the constitution and must not do anything which is inconsistent with the constitution. In a federal system like ours, independence of the judiciary is an essential feature so that the sentenced states may equally respect its decision with respect to the matters affecting them. Article 13 Clause 2 expressly prohibits the state from making any law which takes away or abridges the fundamental rights enshrined in the Constitution, and any law made in contravention of this provision shall, to the extent of inconsistency, be void. The inclusion of provision appears to be due to the abundant caution, because even in the absence of such a provision, the courts would still have the power to examine the constitutionality of the law on the grounds of infringement of fundamental rights. This is so because the judges are bound by an oath to uphold the constitution, and the courts can be approached for the enforcement of fundamental rights. One of the unique features of the Constitution is that a person has a fundamental right to approach the Supreme Court. Moreover, wide, original, and appellate jurisdictions have been given to the Supreme Court and the High Courts to adjudicate on the constitutionality of any disputed matter. Parliament and state legislatures have only those powers which the Constitution confers on them. Therefore, any exercise of power by them may be questioned on the grounds of not being consistent with the Constitution. This power of the court is technically called the power of judicial review. Power of judicial review in our Constitution is not confined to determining the validity of the laws made by Parliament and the state legislatures. It also extends to examining the validity of constitutional amendments on the ground that an amendment violates the basic structure or features of the Constitution. More than once, the Supreme Court has held the judicial independence and judicial review are the basic features of Constitution which cannot be taken away even by an amendment of the Constitution. Judicial activism. Since about the mid 20th century, a version of judicial review has acquired the nickname of judicial activism, especially in the US. That expression has been quite a vogue in India too since the closing years of the last century and is currently a hotly debated subject. Though in India, the participants in the debate mix up judicial activism with judicial review. The former is that form of latter in which judges participate in lawmaking policies. That is, not only they uphold or invalidate laws in terms of constitutional provisions, but also exercise their policy preferences in doing so. With the widening jurisdiction of the courts, especially through the instrument of public interest litigation, the issue of judicial activism has become a matter of national concern. It requires an amicable solution through scholarly exercises and broader consensus on constitutional values between the judiciary on one hand and the legislature and the executive on the other. Thank you.